violence, ahimsa, and customary abstinence, which is maintained qua these forests. And therefore, my lords, if a worshipper damages or hurts the forest in any manner, there is a penance, etc., customary. Now, what is important is also that these orans or devans are unique from one another. So you may have a certain stretch. So it's a common belief system arising from Rig Veda, but each oran is a separate, unique one because it is consecrated to a different Kul Devi. They have their own folklore, their own customs. So one is distinct from the other. Why, my lords, this is important? Because this is about village folk. It's not very organized. They don't have that sophisticated, my lords, organizational skills. And therefore, my lords, they fall between two stools, between the essential religious practices and denomination. So this is what, my lords, I want to, therefore, in the tracing the relationship between 25 and 26, I want to emphasize, my lords, a better appreciation, perhaps, if I may say so, of the expression denomination. Because in our respectful submission, we are entitled to rights under 25 that nobody can dispute. But even to enjoy 25, we need 26. And I will establish that. Now, my lords, there's no dispute. 25 and 26 are in many ways distinct rights. One is individual, as we understand it. The other is institutional, right? But the relationship between the two is one of, my lords, it's symbiotic and reciprocal. In that, my lords, what would the institution be? What would the institutional right be without the followers? It's an empty, hollow right. It exists in order to sustain, to educate, to further the right to propagate, to believe, the freedom of conscience of the individual believer. So, my lords, in our respectful submission, because 26 is essentially there to subserve the rights of individual believers under 25, and therefore 26, even though it may have its own status, it has its own identity, but it is ultimately, it's a means to an end. It's a means to an end to ensure that the individual under 25 is fully facilitated in being able to practice, propagate, and the freedom of conscience. And I'll just come to that in a moment. But, my lords, when we look, sorry.
Just interrupting you. What do you mean they have the persons who represent? They believe in what? I couldn't understand.
Yes. So, my lord, these are called sacred groves, as in, my lords,
what will be the areas and all?
My lords, these are, for instance, in Western Rajasthan in particular, and there are sacred groves across the country.
Forest.
There are forests.
No. Madam, then probably we are entering into some dangerous territory. By that logic, the tribal would say, entire forest is mine. I have been worshipping this. There has to be some limitation. You can't be so vague that this entire area, I believe in a...
That limitation is in 25.
Some circumspection.
Yes. So that limitation will be in 25 and 26. Of course, we are, my lords, ecologically also, it's been recognized from a preservation of forest and ecology point of view. But today we are on 25 and 26. And therefore, I am entitled to the rights, whatever...
The foundational facts is... We can't abstractly...
I'm not asking your lordships, and I cannot ask your lordships to determine my rights over here, but I am asking your lordships to take this. This is judicially determined also insofar as the rights of believers in sacred groves are concerned. We have, for instance, Niyamgiri Hills. I'm not representing them, but we have the Niyam Raja from Niyamgiri Hills. There are water temples in Uttarakhand. There are all sorts of form of nature where nature is revered, and this is really important for our current issues also on ecology and climate change. So, my lord, we will have restrictions, but only governed under 25.
Worship.
Yes.
The form of worship, it can be a religious practice. Nobody is denouncing it.
Yes.
Your right, your conscience, nobody is denouncing it.
Right.
So there is nothing that you see that you can seek as such.
So
already protected under 25(1).
My lords, there are inroads into it. There are inroads through, my lords. There will be vested interests, there will be builders, there will be all sorts of things which come into the picture. But let me not get into too many details, but there are inroads, which is why we are here. Now, my lords, I wanted to explain on the principle, once we look at 26, and this is true of anybody, my lords, 26 is a means to an end. Ultimately, it cannot exist by itself. There's no institution without believers, or at least potential believers. Right. One, if that is so, and secondly, if all persons are equally entitled to the freedom of conscience, right to practice, propagate, preach, etc., and propagate, then, my lords, seeing these two provisions together, then what does it mean? All persons are equally in this context. It means that if you and I belong to different religious affiliations, we are all entitled to the support of an institutional right. And let me explain this. So it may be that I belong to a group which does not fall into the, what I would describe only as tick the boxes definition of denomination, common faith, common name, common organization. And I'm emphasizing organization. What if my group doesn't belong, but my neighbor's group does belong? Then how will it inform our respective right to freely, even conscience, right to practice, propagate, etc.? How will it work out? Now, for instance, my lord, even when we talk of the most personal and private of rights amongst the range of rights that are afforded under 25, your lordships will see right to the freedom of conscience is the most personal and private. Nonetheless, even this right will not be in a vacuum, because as a believer who wants to practice that freedom of conscience, even in the privacy of my home, I may require, my lords, for instance, religious texts to read. I may require access to libraries. I may choose not to, but I may require the support of an institutional apparatus, of an organizational structure. I may want to go to a monastery and learn from the experts over there, etc. So in that regard, even for the freedom of conscience, which is the most private and personal of the range of rights afforded under 25, I will be nourished, my right to freedom of religion will be nourished and supported and sustained by the rights that I get from the institutional. An institution may not be a building with, it can be anything, the collective. I may require mentorship. Even that is an institutional right. Guidance, whatever it be. So each of these rights, and particularly, my lord, propagate, which is the most, my lord's, outward manifestation perhaps of the freedom of religion, for that I will most likely require the assistance and support of the institution. So if we see these together, please now see the definition of denominational, how discriminatory it would be if I don't fit, my group does not fit into that tick the boxes denomination, whereas somebody else's does. So that will, my lords, denude and impoverish my right to religion under 25. So therefore, my lords, and I am supported in this, and when we read Shirur Mat and the definition of denomination in Shirur Mat, my lords, I don't know why it is, but the court chose a very restrictive definition which requires all of this. What happens, my lords? Emphasis on organization. My lords, we, for instance, would be village folk, rustic. We don't, for organization and to fulfill that requirement as stands today of denomination, you require resources, you require organizational skills, you require a whole, my lord, a whole apparatus you require.
We understand your argument. Your argument is there is nothing different between 25 and 26. 26 is meant to give effect to 25.
Yes.
What is important is a conscious and common belief. So there's not much of a difference between persons and the institution. Institutions are meant to give effect to the right to practice, profess, and then propagate.
It is a meaningless right.
It's aim to achieve the mean. So therefore, it is to be understood that way. Therefore, no question of reading it together, or you can say that it's harmonious construction. All those things are not required, because one follows other. Because if 26 stands alone, say like they're contending, it's a standalone article. Then right into 25 will go.
Correct.
Say,
Who does it exist for? 26 is not
nothing but a collection of the common believers.
Yes.
Who created the institution only to propagate and profess.
Right.
That's what you're saying, Xavier.
So my lord, I maintain, however,
therefore, the definition of religious denomination will have to be given a wider import.
much wider, and my lord,
What you're saying, it should be given a wider import, number one. Court should not get into it, because it comes under 25. See, it is protected under 25. So it is actually 26. You have to It is only for management and administration. Otherwise, rights are also there in 25.
My lord, I would just refine it to this extent. I maintain that 25 and 26 are qualitatively and in content distinct rights. 25 is the right of the individual, all persons equally, but not an institution. The 26 right is of the institution. In order for me to be able to, and institution in the sense, it may be organized religion, it may be not so organized religion, but it is a collective and institution, etc. Now, to enjoy 25, which is the individual's right, I need 26, and 26 will not exist but for the believers in 25. That is my short answer on that.
This is Surur, it says, there's one passage in Surur, it says, whatever happens in temple, church or mosques, we are not concerned. What is relevant is the right ensured in the 25.
Yes.
So long as that is there.
Yes.
Now, these other things will be, what they mean is the religious denomination also.
Correct.
The idea is to protect the right in a 25. If you, with that mind, if you read 26,
absolutely,
there is no need to read part 3 into it, whether it have an independent right, conscience, all those things are not right.
Yes, and I'm also saying, my lords, that ultimately, in order to be able to, my lords, you need organizational skills. It can't be all persons equally means we are people who belong to different.
Right, practice and professor.
Yes.
And then propagate.
And it would impoverish my right under 25 if you are not going to treat me as a denomination.
Cannot be also read rigidly. Cannot be
denomination. Yes.
Yes.
And I have,
These
my lords,
people
in this regard.
follow a particular practice. They've come to that. It will, a rigid organization is not necessary.
Right.
They
My
all
lords, what
follow
I
a
have,
practice.
I have put in my written submissions, my lords, I have.
In other words, what will be put it simply?
Meanings.
The denomination, religious denomination, it is nothing but a creation of the collective rights of the common believers.
Absolutely.
Yes.
Which your lord, what your lord
Therefore,
say.
it derives its existence, functions, performance to the collective
Absolutely.
common believers.
Absolutely.
In other words, a denomination cannot go against the common believers. It will only give effect to the common believers.
Correct.
That's
And my lords, if your lordships require any meanings of denomination, they are set out from Black's Law Dictionary to Webster's to all of them, give a much, much wider. And that's in my written submission. My lord, the other point that I did want to make here is ultimately what the court, my lord, ultimately your lords are assisted by the bar. But what has happened is that instead of treating the right as fundamental, it is the restrictions which have been treated as fundamental, because when we talk, my lords, if there are two interpretations available, say of denomination, what is a denomination? If there are two interpretations available, the court must adopt the meaning which furthers the fundamental right, because the right is the one that is fundamental, rather than to constrict it and box it into this, tick the boxes. Are you an organization? Are you this? Are you that?
Already argued.
Yes. So, my lords, therefore, that is one aspect. Now, my lord, the other aspect, please do consider, because what will happen otherwise is this is a recipe for, my lord's, competition to gain denominational status. It will lead to polarization. It will lead to a sort of survival of the fittest. He who has the resources, he who has the organizational skills and the wherewithal will be able to get the recognition, and therefore their rights will be, in a sense, higher than mine. So that is, my lords, and that polarization, my lords, violates the fraternity principle. So please do bear that in mind.
If there is polarization, the state will step in under Article 25 2B. That is reform.
My lords, reform,
So,
yes, yes.
that is why in Venkatramana Devru they said, ultimately you see what is the right here, what is the right there. If as you are saying there is polarization, then the state can step in under 25 2B with regard to social reform.
If social reform is required, if there's a social evil to be addressed,
Necessarily.
my lord, it can't be just an improvement. That's my submission.
If social reform is required, you said polarization.
Well, polarization is in the context of this competition. You and I'm a denomination. You are not a denomination. Let's get the status.
It doesn't apply. That is not the subject matter actually.
My lords, we are.
We are saying that some denomination is superior or some other denomination is inferior. That is not the.
No, not at all. Question is, am I a denomination or not? That's the question. Do I get the right under 26 or not? That's the question. And if that is the question, then, my lords, it cannot be that because you tick the boxes, you get that
Right.
status.
See, what it means is some religious practice is followed by a religious denomination. Their autonomy to practice that religious practice
Yes.
is protected under 26B. The state or the court cannot say, no, this is not a religious practice, you don't have a protection. That autonomy is protected. That is what 26B says.
That's correct. But yes.
In the guise of saying I have this autonomy to protect a religious practice, I will do something which is affecting society as such.
No.
Then 25(2)B state will step in.
Right.
That is how you have to harmonize.
My lords,
That's what
I would
Venkata
respectfully submit that today we are only, as far as I am concerned, my submission is only on who is constituting that denomination and who is entitled to the autonomy under 26.
You understood that part.
That is the absolute. My lords, therefore I just submit there are a few more submissions.
Mr. Jawan,
And-
we are probably not here to decide which is a denomination or not.
We'll see what.
But in an interpretation of 26.
These are not the procedure.
Not a particular, but the principles. The principles, your
It
lordships.
can never be a final. Case to case.
Controversy in this case.
When you have a real grievance, you come case to case, it will be.
No, that of
Then I-
course, but your
the
lordships
state box,
will interpret as to what is a denomination.
Well,
I'm grateful. my lord.
We sum up your argument on the 26, we say, if the essence of 25 is to be seen in 26, do not get into this, leave it to us, is what you are saying.
Yes.
My lords, I will take 10
Just,
minutes, my lords.
Just 2 minutes, not take.
Wait, don't yourself start. I will have to decide who will come first.
Yes, my lord.
Small argument note, my lords. Already my submissions are there on record, my
Please
lords.
don't go to your notes now.
Yes.
Nobody will refer to notes. You straight raise your point, we will note down.
Yes, my lords.
Otherwise, each one,
My lords.
yes.
Yes, my lords. My lords, I am on the historical part of the temple, my lords. My lords, here what has happened is there is a Tripati Danam which has been executed by the king, my lords, in 1750.
Straight
Now,
from
my
the
lords,
point.
that's on the sovereignty of the kingdom, my lords, and which then goes on to the sovereignty of the state and then the sovereignty of the deity, my lords. Therefore, my lords, there are documents which have been executed, starting from the Tripati Dhanam, then the proclamation of 1936. Now, my lords, by the proclamation of 1936, my lords, various persons under the SC-ST category, like my lords, the applicant here, my lords, she is from this community and she has been given the rights to enter the temple. Now, my lords, from there on, my lords, till, my lords, the objective resolution, my lords, which has also been brought out in the Keshavananda judgment, my lords, all these provide that it is the sovereignty of the deity which has to be respected. From there, my lords, to the preamble and 26(2), my lords. Therefore, what we are saying is, my lords, 26 really protects the rights of all the religious denominations and the sects, my lords. All those rights need to be given their equal protection, my lords, and that balance has to be brought out. My lords, just 2 lines from the judgments, my lords, where it has not been relied, not quoted, my lords. TMA Pai, my lords, has brought out, my lords, this fine distinction, my lords. I have quoted that, my lords, which is at page 2198 of the compilation, my lords.
Because
In TMA Pai, my lords.
Just read.
Yes,
Which
I'm
volume?
so, I'm so obliged. TMA Pai, my lords. Article 25 gives to all persons the freedom of conscience and the right to freely profess, practice, propagate religion. That right, however, is not absolute. The opening words of 25(1) make the right subject to public order, morality, health, and also to the other parts of Part 3 of the Constitution. This would mean that the right given to a person under 25(1) can be curtailed or regulated if the exercise of that right would violate other provisions of Part 3 of the Constitution. Therefore, my lords, where 26, and therefore, my lords, between 25 and 26, if 25, my lords, is trying to violate upon 26, my lords, that can be curtailed is what the Honorable 11 judges of this Honorable Court have held. And, my lords, thereafter, my lords, one more para below that, my lords, the freedom to manage religious affairs is provided in 26. This article gives the right to every religious denomination or any section thereof to exercise the rights of, that it stipulates. However, this right has to be exercised in a manner that is in conformity with public order, morality, health. Clause A of the 26 gives a religious denomination that right to establish and maintain institution for religious and charitable purposes. There is no dispute that the establishment of an educational institution comes within the purview. Now, look at the next line. Therefore, while 25(1) grants the freedom of conscience and the right to profess, practice, and propagate religion, 26 can be said to be complementary to it and provides for every religious denomination or any section thereof to exercise the rights mentioned therein. Therefore, my lords, it has to be considered 26 as complementary to 25. 25 cannot supersede on 26 is my argument, my lords. And, my lords, thereafter, my lords, SP Mittal's judgment, my lords, I have quoted out 2 paras, my lords. SP Mittal has been read out, my lords, on the religion part and how it has to be considered. My lords, in Maneka Gandhi, my lords, just 3 lines of Maneka Gandhi, my lords, on the proportionality principle that your lordships, Justice Bagchi was referring to, because Maneka Gandhi says, we do not think that this would be a correct way of interpreting the provisions of the Constitution conferring fundamental rights. The attempt of the court should be to expand the reach and ambit of the fundamental rights rather than attenuate their meaning and content by a process of judicial construction. Therefore, my submission is that a construction should be made so as to give it an expansive meaning. Referring to Article 26, my lord, it has to be given its expansive meaning in a way, my lords, whereby all the religious denominations, all the sections are covered. My lords, in detail, what is a religious denomination, what is the section has already been explained, my lords. My lords, sovereignty of the place, my lords, we are also saying that the temple, my lords, is a sovereign place itself. The deity resides over there, and therefore it has its own unique feature, and therefore the importance to that place has to be given its due weightage. I know, my lords, your lordships are not going into each facts, but, my lords, then, my lords, when the questions of law are being considered, my lords, your lordships will have to determine where do we strike a balance, my lords, between 25 and 26, my lords. 3 paras, my lords, which I have brought out in my written submission at page 11, my lords. Just 3 paras, my lords, very short 3 lines, my lords, between the interplay, my lords, in this background. I'm sorry, my lords.
Para numbers?
Yes, paras 25, 26, 27 of my this argument note.
All right.
The significance of Article 26 of the Constitution assumes great importance as a constitutional provision capable of serving as a beacon of light to the entire world by guaranteeing to every religious denomination or section thereof the right to manage its own affairs. In matters of religion, the Constitution of India provides a framework for peaceful coexistence amongst diverse traditions of worship. The applicant submits that 26 was conceived as a constitutional safeguard for the independent functioning of the religious traditions and the institution. The pious purpose underlying the provision is therefore to ensure that diverse modes of worship may coexist within a constitutional order founded upon fraternity, dignity, and unity. And therefore, my lords, I would say, my lords, this writ petition which has been filed, my lords, therefore your lordships will also have to lay down.
Don't try to be impatient. Otherwise, I will close the proceeding.
I'm sorry, I'm sorry.
Mr. Upadhyay, 5 minutes.
Mullahs, Mullahs, only last point, Mullahs, that Mullahs under 32, Mullahs, these rights should be curtailed, Mullahs. There is Article 363 also, which provides, Mullahs, where there are rights flowing before the Constitution, Mullahs. How do you determine that? And therefore, wherever those rights of the kingdom are being taken away, Mullahs, that will have to be appreciated under 363. I'm so obliged.
Thank you. Mr. Upadhyay, no reference.
Will not repeat even single sentence. So I humbly
We
request,
will, yes, you start your,
my lord,
you leave our homework to us, you complete yours.
my lord, this submission is in 3 parts, my lord. The first on the 7 questions of law and the 7 frequently asked questions asked by your lordships and my submission on the Sabrimala. Second part, my lord, is the relation between Article 25, 26 and 29, 30. The third part is, my lord, dharma and religion. Lordship's motto is the yato dharmas tato jaya, not yato sampradayo tata jaya. High Court motto is the satyameva jayate. And your lordship submission is the yato dharmas tato jaya, because dharma is above the satya. So I have dealt, my lord, in third part. My lord, just see my brief, my lord.
Please start.
Yes.
We are concentrating on you.
So as far as the, my lord, Article 25 and 26 is concerned, my lord.
Come the third part, that's better, no? Because that's a new point you're raising.
No, I will also, my lord, say, just see the constitutional oath of your lordships and constitutional oath of the ministers, union ministers, and the constitutional oath of the ministers. So lordships oath,
Whatever you want, you have asked for 10 minutes, we have granted you 5.
my lord, this is
Your
totally
charge-
new, my lord. Those is totally
What
new.
was 10 minutes you have asked?
Yes, my lord, definitely.
Please confine to that.
So lordship's oath is to uphold the constitution. Just see the schedule 7. Oath of the legislature and executive is act according to the constitution. Upholding the constitution has higher value than acting according to the constitution. Third, my lord, Bharat have been divided in last 2000 years in 25 pieces. That was not due to religious conflict between individuals. Bharat divided in 25 pieces in last 2000 years due to denomination conflicts. And in last 200 years, Bharat divided in 7 countries. Third, my lord, I have also considered that every action has a reaction. Similarly, every judgment has a ramification. Being an engineer, my lord, earlier I was an engineer. So I did the 5W analysis, the Wi-Fi analysis. What will happen if the lordships will accept my senior's argument? What will happen if not accept argument? What will the ramification? Whether in next 25 years, we will become a united, integrated, scientifically developed country like China, Singapore, Japan, or in next 25 years, we will become countries like Pakistan, Afghanistan, and Bangladesh. So I have all the reasons, my lord. Let me see the under Article 25 and 26. Article 25 and 26 is the most restricted provision. None of the fundamental rights so restricted, my lord. Right to propagate religion has not been given in those 10 countries. From we adopted some parts. The 10 countries we have taken something from the South Africa, from Germany, etc. my lord. Even those countries have not given right to propagate not only the denomination, even to the individuals, even till date. So Article 25, subject to public order, health and morality, subject to 27, subject to 28, expressly subject to other parts of the provision. Article 26, subject to public order, health and morality, impliedly subject to other provisions, and expressly subject to 27 and 21. My submission is, my lord, 26 is the SPC, 25 is the genus. SPC cannot have the wider area than it's a genus. So, my lord, just see the brief. Just see the brief. There is a brief. First page, my lord. दे रहा हूं सर, दे रहा हूं. The 9 judges bench of this honorable court will not only decide the 7 questions of law, but also decide the future of the country for next 7 decades. The interpretation of Article 25-26 will decide whether we would achieve the golden goals of the Constitution and become a united, integrated, and scientifically developed nation by 2047, or a radicalized country full of superstition, black magic, delusion, and dogmas. The sui generis case of Sabrimala is not being assailed here. Is it a long-standing custom which is in consonance with public order, health, and morality, and other provisions of Part 3? I have dealt in para 22, para 32, 30.
Straight come to the point, Mr.
Yes.
There is no
Then,
time.
madam, main argument. Just see the middle, main argument. Just, I request,
No,
madam.
that's right, but we don't have
Yes.
time.
You can summarize your
We have to
Yes.
grant time to the others also.
The main argument, individual possess the right to propagate religion while the denominations do not. possess such right. The constitution framers put the express restriction of the being subject to part 3 in Article 25, while not doing so deliberately on Article 26, as Article 25 granted the right to propagate religion on individuals, while Article 26 did not grant any such right to any denomination or sections thereof. Even the anti-conversion laws enacted in the different states are based on the premise that only an individual can propagate, convert lawfully or unlawfully. The intent of the premise was also, as the root cause of the 1947 partition was denomination versus denomination conflict, not the individual versus individual conflict. Had persons propagated their religion peacefully, such a conflict would not have arisen. Notably, the 10 constitutions from which we adopted various parts of the constitution, neither back then nor even today have the conferred right to propagate religion on their citizens. Only after much deliberation was this right included in the constitution, with an express subjection to the other fundamental rights, keeping in mind its a dangerous nature. All the other articles are already impliedly subject to the other fundamental rights. Well, there is some argument. It was tried to connect Article 29-30 with the Article 26-27. My submission is this. Though Article 29-30 have been tried to argued in this case, but they are not relevant in this case. Minorities were given certain protection in regard to their culture and education. Therefore, Article 29-30 covered under cultural and education right. Had they been intended to confer religious right upon minorities, the framers would have not been made their heading to so exhaustive. Thus, Article 29-30 are not to be dealt with in regard to right to freedom of religion and should be seen as completely distinct from them. The observation in few cases that Article 30 is an extension of Article 26 is therefore per incurium. My lord, petition is pending and before the refer to the 7-judge bench. Next, my lord, I have considered, my lord, few points. Number one, the dreams of the freedom fighters, the dreams of the constitution makers, the language restriction. My lord, Samvidhan is not the constitution. With utmost respect, I'm saying. We don't have the proper words for Samvidhan. Samvidhan, samadhan vidhan. Yani sabke liye saman vidhan. Yani samyak vidhan. Constitution means vidhan. Because there is a limitation. In English, we have only 26 alphabets. We have total only around 10 lakhs words. In Sanskrit, we have 52 alphabets. We have around 50 lakhs words. And that's why, my lord, Honorable Dr. Ambedkar introduced a bill in the Constituent Assembly. Please make Sanskrit as the official language of Bharat. Unfortunately, that bill will fail, my lord. So when we interpret, my lord, things in English, it becomes very difficult, my lord. Similarly, dharma and religion. I have not cited any previous judgment because the previous judgments are based on the assumption that dharma is religion and religion is dharma. It is totally different, my lord. My PIL is pending. Lordships have issued notice to the center also. I have requested to please introduce one chapter in primary. What is the dharma and what is religion? I have differentiated 25 differences between dharma and religion, my lord. I can summarize this. Dharma includes everyone. Religion excludes everyone. Others. Dharma unites society and religion divides society. That's why I have not cited the previous judgment, because there are assumptions based on dharma and religion, my lord. Then, my lord, I have also considered, my lord, why this lord system came. We generally say, my lord, lordships. This came from the system of Panch Parmeshwar. Earlier we have the system of Panch Parmeshwar. 5 log बैठते थे, वो decide करते थे. And what was that vidhan? That was the vidhi ka vidhan. And what is the vidhi ka vidhan? That is the samyak vidhan. That is the samvidhan. So this is samvidhan is different. Unfortunately, we don't have the exact word for the samvidhan. We don't have the word for brahmacharya. We don't have the word for dharma. We don't have from word for yoga, etc. My lord. I also consider, my lord, there is, my lord, frequently said all religions are same. Not at all. Not at all. My third page is the 5 tenets of religions. I have given the 5 tenets of all the religions, my lord. Totally different. This is Ramayana. There is not a single sentence. You follow Ramayana, you pray Lord Ram, if you will not follow Ramayana, will not pray Lord Ram, you will go to Naraka. No, not at all. This is my Lord Vishnu Puran. एक वाक्य नहीं लिखा है कि केवल भगवान विष्णु ही पूजा योग्य है, विष्णु पुराण को ही मानो, अगर नहीं मानोगे तो नरक में जाओगे, नहीं लिखा है। ये भगवत गीता, एक सेंटेंस नहीं लिखा है, भगवत गीता को मानो, कृष्ण को मानो, नहीं करोगे तो नरक में जाओगे।
You are going beyond the subject and issue being discussed by every one of us. You said 52 alphabets in Sanskrit, one of the finest language in the world.
Yeah, my lord.
Similarly,
Yes.
Tamil has 247.
Yes, my lord. Yes,
So
yes.
don't go into all those areas.
No. What I am,
Confine yourself to the point in issue.
my point is, my lord,
Yes.
if we will interpret the constitution in English, then today we have the 9 judges bench, tomorrow we have 11. No in. If we will interpret, considering it as Samvidhan, and what is the meaning, then we have different.
In Kannada, there are 52. So therefore, don't
Yes,
go
yes,
into.
yes. No, all the Indians, oh, sorry.
See, all
I am,
are equal.
I am sorry. I am sorry. All the Indian language have the 52.
Don't go into
52 alphabet.
superiority in the court of law, please.
No, my last submission is, this is Durga Sapsati. एक शब्द सेंटेंस नहीं लिखा है, केवल दुर्गा जी की पूजा करो, दुर्गा सप्तशती पढ़ो, नहीं तो नरक में चले जाओगे। आर्य समाज, also denomination, not a single sentence. Please follow Arya Samaj. Please follow. Very important, my lord.
Sorry,
Fit all this.
we have to stop you.
Yes.
It's not a public platform.
Interpretation.
My submission is this: dharma and religion is not same, and all religions also not same. Entire world is burning due to religious conflict. Bharat was divided in 25 countries due to denomination conflict, religious conflict. So my submission is this, my lord.
Time is over, Mr. Upadhyay.
Yes. Now I will do only conclusion. Just see, my lord, conclusion. The conclusion, my lord, at page number 12. Article 25 is expressly subject to all other fundamental rights because it's conferred a novel right to propagate religion on individuals, unlike any of the nations from which we adopted our constitution. Article 26 does not confer right to propagate religion on religious denominations. The intent of the framer was never to grant right to propagate religion to religious denomination in light of the damage that was done by them before and during the 1947 partition and massive massacre. Article 26 is impliedly subject to the other provisions of Part 3 of the Constitution, like the other. Now, my lord, next conclusion on Sabrimala case, my lord. There are lakhs of mosques, but the Makkah, Medina have a distinct sanctity. There are lakhs of churches, but Jerusalem church has a distinct sanctity. There are thousands of Shiv temples, but Bharat Jyotirlings have distinct sanctity, my lord. There are lakhs of goddess temple, but 51 Shaktipeeths have distinct sanctity. Thousands of Jain mandirs, but the temples made on the birthplace of the 24 Tirthankar have different sanctity, my lord. Similarly, my lord, there are 1500 Sabrimala temple, but this temple has a distinct sanctity because no, Vice my lord.
That's what you're saying.
I am saying that restriction on 10 to 50 is reasonable. So that's why I'm here, my lord. Because lordships are deciding the 7 questions of law, and I am supporting the Sabrimala case, my lord. That's why I'm this side.
Thank you.
Ma'am, just my lord. One conclusion, my lord. I am only reading conclusion out only, my lord. My lord, just see the page of 25. Conclusion.
Yes.
Article 30 was conceived by a framers of the Constitution as a response to the specific anxiety of minority communities, particularly in the shadow of partition, that the majority, through the instrument of state educational policy, might systematically erode minority languages.
Going to Article 30, that is not.
Because
statement
some argument was there that this is the, so I am skipping lordships at that.
You are not responding to arguments. You are only giving your
Then my lord,
point.
just see the dharma last page as page 35.
Now you have beautifully explained to us. We understood that.
My lord, the conclusion.
Beyond religion, you said. Yes, sir.
Dharma cannot be translated as a religion. Constitutional provisions touching upon dharma must be interpreted with the conscious awareness of that distinction. Dharma is universal, reason-based, inclusive, ecologically balanced framework of duty conduct available to every human being, regardless of creed. It demands conduct, not belief, and draws to the boundary between believers and non-believers. Religion, as the term is understood in tradition from which its constitutional usage derives, is traditional bound, text-anchored, community-specific, and structurally exclusive. Its boundary between the faithful and the faithless has historically been a source of conflict and injustice. The Constitution is in foundational commitment a dharmic document. Constitutional protections.
We got it.
I am only
You
saying.
fully argued on behalf of the respondent.
Well, let's just see.
Thank you.
Dharma gives liberty of thought, liberty of belief, liberty of faith, liberty of worship. Religion does not. Dharma says, Vasdhev Kutumbakam, Nari tu Narayani, Sarva Mangal Mangale, Sive Sarva Sadike, Yato Dharmas Tato Jaya. Religion does not. Religion says, if you are in my area,
Swadhyaya, every religion has its own dharma.
Malat,
Yes.
with utmost respect, Malat,
Don't think that.
Right, we heard it.
all the religions don't give
Right, yes.
Vasudhaiva Kutumbakam concept, don't give one earth, one family concept, don't give Janni Janmabhumisha concept, don't give Sarva Mangal Mangale concept.
Understanding, please,
Kindly understand your
please
responsibility.
don't argue like this, leave it there. Yes.
Malat,
This is absolutely,
It's not in good taste.
Malat, it may be some bitter truth.
Please,
It may be some bitter truth.
absolutely not, Mr. Counsel. You have to understand the scope of this argument.
Don't, with the limited understanding, please don't.
Malat,
Leave it at that. Or we heard
I'm
it.
only saying
Yes.
Article 25 and 26 gives freedom of religion, not freedom of dharma. Article 24, Article 14, 15, 16, 17, 28, 18 is the promote dharma. Article 19, dharma with some restrictions. Article 21 is dharma. Only Article 24 and 25 and 26 gives freedom of religion. Other rights, other fundamental rights are in the nature of dharma. So please keep in this mind, Mala. So this is my humble request.
Will go, only the religious rights will not be upheld.
No.
Already we heard it.
I am saying this Article 25 and 26 is the most restricted right. Most restricted.
We understood your argument is that rest of the fundamental rights are emanating from dharma.
Yes.
Therefore, they have wider contour.
Yes.
They have wider meaning, and they are comparatively very stronger rights as compared to very restricted
Yes,
right
sir.
in 25.
Because it was argued that Article 26 has some different island. It was said Article 25, 26 is higher than even 25.
Thank you.
I am saying no.
Thank you, Mr.
Oblige,
Kumar.
Malak.
Thank you.
Oblige.
Thank you. Thank you very much. Yes, Mr. Dinesh. Yes. 2 minutes, please.
My lord's already granted me 10 minutes.
Just take the mic and state start.
I will not repeat any single word which I argued by senior colleagues. It's all together totally new points.
Take the
And my
mic.
lord, my submission.
Start to the point.
Yes,
And
my lord.
no reference to any note, etc.
Yes, my lord.
We will examine note. We have a lot of vacations,
Excuse me.
partial working days.
Partial working, partial vacation, partial working.
My lords, my submission, the crux of my submission, my lords.
You
If
take the mic first of all, you and state start. Keep them here.
yes, my lords.
Don't give it. Yes.
My lords, if this rituals and custom is nothing to do with the religious cruelty, as observed by Justice Indu Malhotra in Para 8, then, my lords, the scope of judicial review is very less. My lords, may kindly come to page 76 of my note. Page 76 of my note.
Yes, please read that.
My lord, I will read.
Only one line, with
Where is your
punch
note?
line.
Where is your note, please?
My lord, page 76, para 3. It says that it is extracted from the judgment. The difficulty lies in applying the test under Article 14 to religious practices, which are also protected as fundamental rights under our Constitution. The right to equality claimed by the British under Article 14 conflicts with the rights of worshippers of this shrine, which is also fundamental right guaranteed by Articles 25, 26 of the Constitution. It would compel the court to undertake judicial review under Article 14 to delineate the rationality of the religious beliefs or practices which would be outside the ken of the courts. It is not for the courts to determine which of these practices of faith are to be struck down, except if they are pernicious, oppressive, or social evil like sati. So therefore, my lords, this is a dissenting judgment. This was my first layer of my argument for 5 judges bench, my lords. Now, my lords, may kindly come to page 14, quickly, my lords. What is the religious cruelty discussed by Commonwealth Assembly in 1858? In 1858, Commonwealth of Australia Assembly debates, page 14. Well, I give some time, it will be extremely, and I want to read the executive order issued by the White House.
No, that we will not permit.
Yes.
If you give to us, we will read it.
Yes, my lord. Now, my lord, page 14 at page 21, Commonwealth Assembly debates. What is religious cruelty? Edward Garden for Tasmania. I have an amendment to move on behalf of Tasmania and also an amendment to my own. The clause we have before us says that a state shall not make any law prohibiting the free exercise of any religion. It is quite possible that this might take lawful practices which would otherwise be strictly prohibited. Take, for instance, the Hindus. Well, it's the Hindu spelling is HINDOOS, that type. Hindus. One of their religious rites is sati, and another is the kachak, one meaning simply murder, and the other barbarous cruelty to the devotees who offer themselves for the sacrifice. Then again, yes, if this is to be the law, these people will be able to practice the rites of their religion. And the amendment I have to suggest is this insertion of some such words as this, but shall prevent the performance of any such religious rites, etc. Now, my lords, may come to executive order issued by the White House. Page 32, my lords. It's very important for my purpose. The executive order is always enforceable issuing by the White House. If the crux of that executive order at page 32, my lords. I'm sorry, my lords, it's at page 29. I'm extremely sorry. My lords, it's issued by George W. Bush, saying that your religious practice is very much relative to the society. If it is for social upliftment, if it is for self-purification, like Mandala Vrata in Sabrimala, and if it is for self-renaissance, that practice must be appreciated and part and parcel of the local laws. This is what the executive order issued by George W. Bush. Whether it is enforceable, which I gave a note at page 108. What is the meaning? How it can be issued? Enforceability of an executive order. Now, this is what my one area, that what is the religious cruelty? If it is not religious cruelty, and my practice is up for the upliftment of the society, and it is a self-purification, and it is self-renaissance, the court, the scope of judicial review is very, very less. That is what Justice Indul Malhotra's judgment. Now, my lords, may come to page 78, my lords. Now, I want to see a statistics. It is connected with the Sabrimala Mandala Vrata. Sabrimala Mandala Vratam is having with, like the same having with the Muslims. I have gone through the Holy Bible. Having with the Muslims, I have gone through the Holy Quran. I extracted those pages here. So, all this vratas is for the purification of the self-purification, and that self-purification is for the upliftment of the society that has to be appreciated under law and otherwise by the state also. And 25(2)(b). 25(2)(b) says social welfare. 25(b) says reform. That is what I am doing. Whether any cruelty involved in Sabrimala, there is nothing. But of course, unfortunately, a section of the people projected that religious cruelty is there. A section of the people projected that menstruating lady cannot enter into Shabrimala. No, I am going to prove it. I am competent enough to prove it. Menstruation or menstruating lady cannot enter into Shabrimala is absolutely wrong. That interpretation had been given by some kind of activists, and therefore, my lords, this menses projection is to misguide the court, misguide the society, and that is nothing to do with that. An effective understanding of Mandala Vrata will prove that it is nothing to do with this biological. That is why, my lord, out of 5 honorable judges, Chief Justice Mishra, Justice Kanvilkar, and Justice Sindhu Malhotra, out of 3, in this particular issue, decided on my favor.
Would you please answer the 7th question? Anything to do with this? We are not hearing the review. We are not hearing the review. Please.
Then, my lord, then if there is no religious cruelty, I am not bound to give an answer. That's why I may substantiate this. My lord, I will give that.
Please ask it.
My lord, I will give the answer because of my lord. There is
the time useful by addressing the legal issue. We are not going to that now.
It's legal, my lord. The 3 judges' finding is absolutely legal, and therefore it is bound to be Article 141.
That is with reference to the facts of that case. That we will examine. There is no issue.
Then, my lords.
Legal and law.
Then, my lords, page 85. Why this Mandala Vrata designed accordingly for the men, and why a certain categories. My lords, kindly note that it's only age relation, nothing to do with the ladies' entry. Page 85, my lords, types of prison inmates in central jails, 31st December, it's a crime record bureau. 96% of the men are committing the crime, only 4% under trial as well as convicts. And how this is at page 86, my lords, again, that tobacco consumption, alcoholic consumption, again with the men. My lord, I am coming to what is Mandala Vrata. It is nothing to do with the menstruation. We are pained by hearing this. We are pained. The entire writ petition says so. 2 honorable judges decided the issue on the basis of menstruation. Justice Nariman and Justice Chandrachud. Kindly see, is it a correct fact? No. That is why, my lords, crores of devotees are pained. So, tobacco. Now, my lords, may I kindly directly come to page 37. My lords, that is why the discussion between, because that's why I showed you that present details. Tobacco consumption. This is a family health survey by the government of India. I'm relying all the authoritative records. Krishna and Arjuna, this is what exactly says, my lords, page 37. Arjuna said, "O descendant of Krishna, now impelled by what does this man commit sin against his wish? As though driven by force. Man is not committing the crime. As driven by force." That is what statistics are very important. Now, my lords, again, the blessed Lord said, this lust, this anger, born out of Rajoguna, is insatiable and an awful sinner. Know this to be the enemy here, world, or in the embodied state. My lords, again, 3 pages are extremely important. So, therefore, my lords, that question of Krishna is extremely important. That is what the statistics we have seen 2023.
You understood that part?
Yes, my lords. So, now, my lords, page 38.
Anything on 20?
Page 91, my lords, page 91. My lord, this, my lords, I studied a lot, my lord. First day onwards, I was here.
Thereafter,
Yes, well,
Main case when
if I am disturbing my lords, I don't want to continue.
these are the arguments when the main case will be listed. Here you will have to raise all these arguments. You are unnecessarily preempting.
Yeah.
That's why my first submission, my lords, my first submission is, if there is no religious cruelty, and if it is an essential religious practice, then, my lords, whether I will come under the purview of 7 questions or not, at least if you understand this.
All right, that we have understood.
Now, my lord, page 90, my lords. Page 90, my lords, extremely important, my lords. 2, 3 minutes more. My lords, this is Asian Journal of Medical Sciences. This journal of 5 doctors from different universities of the country gone through these 41 days vrata, Ayyappa Disha. Then they held, it's good for the power, it's good for sleep, good for the health, etc. So therefore, a social upliftment and self-purification mandala vrata is misinterpreted and misprojected before the society and says that because of menstruation. And that's
You are an Ayyappa devotee.
my lords, Ayyappa is much more
Then
for
leave
me.
it to Ayyappa and leave it to us. We heard you. Thank you.
No, my lord, then one more point, my lord. One more point, my lord.
Yes.
My lords, that point is this, my lords. Legally, I have 2 submissions. I have legally 2 submissions. I said something on facts to counter this biological issue. Now, my lords, 25(2)B, I already indicated to your lordship that social welfare, 2 minutes, social welfare and reform. I already submitted before my lords my respectful submission. It is social reform, Ramadan, that Sagat, that 50 days no as Jesus Christ observed Bible, like Mandala Vrata. So that is what its importance. Now, my lords, that 25(2)B is clarified me. Now, my lords, 26A, establish and maintain. Establish and maintain. In view of 25(1), in view of 25(1), I established something. Now, in 26, there are 3 important words: maintain, administer, manage. Why it is separately given? A, establish and manage. There are 2 parts. One is establish and manage. Maintain, I'm sorry. My lords, according to my respectful submission, my lord, Justice Sundaresh always wanted to legal issue. Maintain, Justice Vanchu interpreted 5 judges bench matter in connection with the Muslim University, Aligarh Muslim University. Page 71. Which is that judgment. Maintain means continue. Dictionary meaning also continue. Interpretation of the highest court of the country also continue. So in accordance with the 25, I established something. I can continue it if otherwise proved that it is a religious cruelty. Now, my lords, just that, I will just read. What we have said with Justice Vanchu's readings, my lords. I'm sorry, my lord. I understood that, my lord's problem that all are here. My juniors are here. But I'm also, sir, I'm sorry. I'm so not saying about you. You are much senior to me. What we have said with respect to Article 31, which gives right to minorities to establish and administer educational institutions of their choice, applies equally to Clause A of 26. And therefore, we are of opinion that the words establish and maintain must be read conjunctively, and it is only institutions which are related, but it's not. So it must be read conjunctively, establish and continue.
That is on 29 and 30, Mr. Biju. That
No, my lord, what court interpretation I'm saying,
Yeah.
my lords. That, my lords are absolutely right, my lords. With one more sentence, my lords. Kindly see page, my lord, last submission, my lords. It is not just Shabrimala. My lord, though I am just indicating Shabrimala, my general principle is what I am saying is.
there you are absolutely right. It is not Sabrimala only.
Yes,
There are
religious
so
cruelty, religious cruelty. My lord, this in the premises of Shabrimala, there is a small mosque, Vavar Hundi. This is the only temple in the country, according to my limited knowledge, Vavar Hundi. And all the crores of devotees going to this Vavar Nada, Vavar step, that small mosque is there. In the premises of Shabrimala, it is itself. So, my lords, whoever coming, Swamis, they are donating to this Vavar Hundi also. And Juma Masjid, Juma Masjid was the friend of Ayyappa.
All
That
right,
is
thank
what the
you, my
last
lord.
page.
Thank you. That we are.
Yeah.
And therefore, my lord, I am grateful.
Just
my lord.
2 minutes, my lord.
Yes.
Two broad propositions only.
Yes, please start your.
Yes, my lord. First is, my lord, when 25 and 26 are pitted against. Please. I appear for one of the review petitioners, my lord. I'm supporting the Sabrimala review. Now, my lord, the question is when 25 and 26, either individually or together, please. When 25 and 26 individually or together are pitted against other fundamental rights, what is the approach to be taken? Electoral bonds case, your lordship, evolved the double proportionality test. The very first question which is posed in that test is when there's a balance to be done, is one right higher or the other right lower? But my submission is 25 and 26 together, individually separate, are not lower in hierarchy to any other fundamental right. If there has to be an interference, it has to be in a pernicious case, not only sati or human sacrifice. Some time back, reference was made to Colonel Borden for conversion. There was a judgment of Reverend Stanislaus, which was read out earlier. That was exactly a case where, my lord, interference is called for. Also, my lord, in Asha Ranjan versus State of Bihar, your lordships again considered when two rights are to be brought into conflict, or even within the same right, it does not mean that in the exercise of balancing, one fundamental right gets extinguished. No, that is what has actually happened in many of these cases. So, the submission is when the balancing has to take place, wide interpretation has to be given so that all the fundamental rights are given their full scope and play. One example of hierarchy could be right to property. It was removed from 19(1)(f) and put into 300(a). So, in that sense, it was demoted from a constitutional fundamental right to a mere constitutional right. So, if 19(1)(f) or 300(a) comes into conflict with any other right, then yes, one can say that there's a hierarchy, but not in this. Second point, my lord, very quickly, just taking off on denomination, what was argued by Ms. Diwan and Mr. Joshi and others, and some observations which fell from the bench. Shirur Math's judgment, my lord, is taken, the definition of denomination is taken from the Oxford Dictionary. Oxford Dictionary is essentially an English concept where the question is common faith, name, organization. This is follower specific. Lot of reference has been made, my lord, to specific temples in this country where specific worship is followed. But I would just like to take it a step further. Temples are consecrated, particularly our ancient temples at particular places for particular reason. For example, the Shakti Peeths. Worship over there is very specific to what has happened at that place. One example is the Jwala Devi temple in Himachal. Worship is of the fire. I am a Hindu, I can go there, but I will worship according to the rituals that are established at that place. I can't do anything else. I can also go to, let us say, the Jagannath temple in Puri. There the worship is of the idol. Again, I will have to follow the worship of that place. So being a Hindu or a section of a Hindu, the denomination should not be concentrated on me as a follower. It should be concentrated on the place where I am going to offer worship. In that sense, my lord, denomination has to have a much wider concept than what your lordships have held in Shirur Math and followed thereafter. Just to crystallize the point, if a particular place of worship is established for a particular purpose, the priestly lineage has a particular qualification, the rituals follow a particular pattern, then that particular place itself is capable of being defined as a denomination, not the person who goes there. That's the submission. That's all. Now, just with that note, on this point, there is a religious scholar who has written a note on that. I've just handed it up. I'm not going to read anything from that, but I just wanted to place.
Thank you.
Lord,
Thank you, Mr. Rohan. Thank you. Yeah,
A couple
please
of short.
announce your name also next.
Milords Anirudh Sharma. Milords Anirudh Sharma. Milords, a 9 judges bench has already commented on ERP. Hence, Milords, I must, on essential religious practices, in 2 minutes, I'll just place that, Milords, because that becomes very important. If my lords don't notice it, then, Milords, then it opens for 11 judges. Please, Courtmaster.
You have
Milords.
given in the name in the list, then I will stop otherwise.
My lords, it's already there.
Now 2 minutes, please. Huh?
Yes, Milords. 9 judges.
Just 2 minutes. Because your name is not there in the list.
My lords, speaking through Justice Ramaswamy in para 186.
Sharma.
Milords Anirudh Sharma. Milords, 9 judges in Bomai. Justice Ramaswamy comments about essential religious practices. I have quoted it, highlighted it. I'll just read the highlighted portion, my lords. At page 1 itself.
Yeah, please,
My lords, in order to secure constitutional protection, the religious practice should not only be an essential practice, but also be part of an integral part of proponent's religion, but subject to state control. Otherwise, even purely secular practices which are not an essential or integral part of religion are apt to be quoted as religious forums and make a claim for being treated as religious practice. Then he again repeats in para 184. My lords, and then he says that no religious place can be stopped for any caste or any religion. As far as religion is concerned, there can be religious autonomy, not on basis of caste. One particular religion's place may have religious autonomy, so that, my lords, may have to reconsider, because this is 9 judges, it will bind. Second point, my lords, with respect to Bomai, next page, my lords. Again, it says entry only on grounds of caste or religion is outlawed. Next, not on gender. Though it, in my favor, my lords, this was also not the issue raised. So what was the issue raised, which will give the exact ratio, and the exact obiter therefore becomes crucial, because Justice Given Reddy's judgment becomes the lead judgment, as every other lordships then agrees or disagrees with that judgment. What was the issue framed is 304 para number. My lords, what do these articles read together with the preamble signify? So he refers to 14, 15, 16, 25. He takes a holistic view and says, what is it that it signifies? Then he holds, my lords, I have at page 3 stated that no other honorable judge goes into the issue of ERP. I give the para numbers of every honorable judge who deals with the issue. No one says even a single sentence about essential religious practice. So the question before Bomai was not essential religious practice. However, my lords, it creates an interface for future, my lords, where religious morality may conflict with constitutional morality. Bomai is a classic case of that. My lords, next point, my lords, the idea of binding effect of Bomai judgment. What is it that Bomai says, which I respectfully submit will also be binding on this honorable bench of 9 judges, my lords. Bomai says, first thing, that Article 25, 26, 28 constitutes one scheme, and 26, 27, 28 are just facets of 25. So if you don't have anything in 25, nothing works. But then 27 and 28 being part of it, the words in 27, 28 actually help in interpretation of Article 25. And in that, the first point is that there is an equality clause well within 25 itself. 25 uses the word equally, both horizontally as vertically. Equally, individuals of one particular religion, there will be equality. And then when there is interface with the state, all denominations, all religions will be treated equally. Here also, there might be a problem, because if there is nothing in your religion, and if you are claiming, can you claim that equality? Your equality amongst religion will have to be first established that you have some part of it in your religion. Then only you can claim from state. If a particular thing is absent from your religion, there cannot be a formal and a very stale equality. It is a dynamic concept, equality between religions. First, religions will have to be investigated, and then equality will have to be substantiated. Next point is at page number 3. My lords, I have completed that. At page 4, my lords, a short point. That at para 183 of Bomai, again, it says that the Constitution has made demarcation between the personal and the religious. This is Justice Ramaswamy's part, which is binding, because religion will come into the sphere of personal and secular will come in the sphere of public. My lords, then Justice Ahmadi also notices it. He also...
How did all this arise in Bomai?
My lords, because the issue...
Not to exercise of power.
My lords.
Article 356
My lords.
of dismissal of a state government.
My lords. Because secularism was held to be a basic feature question flame, so they analyze all the articles dealing with religious right and says what is secular and what is religion.
Secularism also arose under that exercise of power by the governor under Article.
My lords, but I would respectfully submit that all honorable judges in all the opinions of Bomai have dealt with secularism and the effect of Article 25, 28, 29, 30, 14, 15, 16 with respect to religious equality. And the core of that judgment is that everyone is equal within the religion and everyone is equal also outside the religion. And if that is violated, then the court steps in. The next point on this issue is what Justice Ahmadi says. He cites, I will not read, Hind Swaraj and Pandit Nehru's opinion. He approves Gandhiji's opinion. It says, religion is my personal affair. The state has nothing to do with it. The state will look after secular welfare, health, communication, foreign relation, currency, and so on. So for interpretation of the secular powers of the state, this comes into operation. What is secular? So this is the area where the states can interfere on the grounds on which the state can legislate under 25(2) on grounds of secularism and therefore can enter. To that extent, my lords. My lords, at page 5, the next point is Article 28(2). It has two important words, endowments and trust. It says that though the state may take control of a religious institution, but if it is established by an endowment or a trust, for a particular religion, the religious instructions will continue even if the states take over. And this question was put directly to Dr. Ambedkar, that will it not be, will it not be a violation of secularism? So his views are on page 6, my lords. He says, permitting community which has established its institution for the advancement of its religion or its cultural life to give instructions in the school is allowed. The sum and summation of that is that you establish an endowment, you have a trust. So two things first. Under religious right, you must be having the right to establish endowment. Now, under 25(1). Number two, trust. That is why the word persons is used in 25(1). And Dr. Ambedkar supports it by saying that the endowments and trusts will have constitutional recognition by putting it specifically in the constitution. So all those organizations which can come under 19(1)(c), under the definition of person, and this question was highlighted by my Lord Justice Sundaresh, that a question was framed in Shirur but not answered. Hence, my Lords, 28(2) gives the answer by giving substantial and direct recognition to endowment and trust. So 19(1)(c) comes. So, my Lords, there are three categories now: individual, groups, and denominations. Those groups which may not qualify as denomination may still be having rights. And that is where, my Lords, the third element comes into operation. My Lords are sitting in the 9 judges. No judgment till now has gone into the third aspect in a 145(3) reference. However, my Lords, in those judgments which are not 145(3) reference, they have gone. And my Lords, I have just quoted Parsi Zoroastrian, those paragraphs which are relevant for this purpose. In my written submissions, I won't read it, my Lords.
All right, thank you.
My Lords, just last point, my Lords. As far as, my Lords, this, I have quoted Dr. Ambedkar.
But what is the third aspect? You said you have been gone into.
My Lords, first is individual, second is denomination, third is groups. My Lords, a trust, endowment. An endowment is a pious person. In 30 seconds, I'll give an example, my Lords. Someone creates a well of his own money. It becomes res extra commercium because it's dedicated to the society. Someone makes a temple out of his own earnings for the society welfare. Someone has a drinking system. My Lords, these become rex extra commercium beyond the commercial view, and even the state cannot encroach upon it because state is parent entry. It always has to work in public interest. So someone has made out of his own money a pond, a well, a temple. All these are pious purposes. In Christianity, someone opens a church. In Islam, waqf. These are all pious purposes where you totally dissociate yourself from it and leave it for the general good. That's the last point, my Lords. And my Lords, as far as constitutional morality is concerned, I have just given some additional reasons in my written submissions, which have not been otherwise captured. So, my Lords, to sum up, we have in Maharashtra, my Lords, Ganesh Chaturthi. In West Bengal, we have Durga Pujas. In Bihar, my Lords, and certain other places, other things. These are all arranged by the societies. They are pandals. So even in COVID, my Lords recognize those rights and allowed them to carry on limited sphere. Those are not denominations. Those are neither individuals, but they have rights. So the third factor will be that even if I fail as denomination, or I'm a set of individual, even if I fail as denomination, I would still have some rights if I succeed in the test of evidence, my Lords.
Thank you.
Much obliged.
Thank you. Thank you. For you, 5 minutes.
That's,
You asked for 5, granted 5.
very grateful for that. So, my Lords, I'll briefly state my 3 propositions. These are my submissions. My Lords may read it later. I'm not relying on them for now. My first submission is that the test of hollowing out a religion or eviscerating a religion.
Take the other mic also toward you.
The first submission is that the test of hollowing out a religion or eviscerating a religion as the permissible limit to a 25(2)(b) legislation is both vague and confers the state with massive powers. Now, tomorrow, if a challenge is made to a 25(2)(b) legislation, my Lords will have to decide what is hollowing out as per the tenets of that religion. Then my Lords will have to make an analysis of what are the essential aspects of the religion and non-essential aspects of the religion. Then my Lords will also have to decide whether the practice that the state interferes in results in hollowing out or not. Then the extent of interference results in hollowing out or not. This, my Lords, with respect, my submission is that this is nothing but ERP test in a new cloak of hollowing out of religion test. In fact, this is much wider with much higher threshold, conferring the state with massive powers. In this background, my submission is, my Lords should define the broad contours of state's power under 25(2)(b), lay down basic principles and some guardrails which the states can do and cannot do in exercise of its power under 25(2)(b) under the guise of social welfare and reform. I have suggested 6 guardrails. They are part of my submissions on the interpretation of 25(2)(b). I'll briefly state them. The first is that the expression social welfare and reform takes its color from and is guided by public order, morality, and health, to which the principal Article 25(1) is made subject to. Second is power under 25(2)(b) may be exercised to restrict, regulate, prohibit practices that are against public order, morality, and health. Third is power cannot be used to obliterate rights. Fourth is the literal meaning of social welfare is welfare of the society, which is relatable to public order, morality, and health. Reform presupposes an existence of a pernicious practice that does not include religious reform. On interpretation of non-obstante clause 25(2)(b), I have mentioned that this is contextual. This would mean that the individual right under 25(1) would have to be bypassed for social welfare and reform. However, the extent of interference or the substance of the legislation will still be guided by social welfare and reform, social public order, morality, and health. Sixthly, the power cannot be exercised to give effect to or in pursuance of a DPSP, because that would destroy the fundamental right under 25(1). The legislation will also not be saved by Article 31C. Now, my second submission is what is protected under 25 and 26 are rights which are bona fidely and conscientiously held by the members of the community. Here again, my lords, if the community does not speak in one voice and there is difference of opinion among the members of the community for a particular practice, there again, my lords will have to wear a theological hat and decide whether the belief indeed is held bona fidely and conscientiously by the members of the community. The third point is on locus, my lords. The locus, I have stated very carefully that it has to be of persons who are actually aggrieved by the right. My lords should make it mandatory for the parties to plead in their writ petition that personal right to worship has been violated. Because I made a table of 23 cases that have been decided in the last 75 years, with the exception of Sabrimala and the triple talaq case where my lord suo motu entertained a PIL, registered a PIL. There is no other case in which a PIL was entertained and decided by this honorable court in the interpretation of 25 and 26 right. Very grateful, my lords.
Thank you.
Serial number 9, my lord.
So I've been waiting for a long.
If you can finish by.
Yes, your lordship. I will take, lordship, my written submission is there. It's just a 10-page submission. And lordship, this is EA.
Start, Madam Kumar. Yes, start your from.
Yes, your lordship. This application pertains to Ma Kamakhya Devi Temple, which is in Assam, Guwahati. So I'm about the essential religious practices and the practices which are there, right, for a long time of custom. So I may just read the brief history, which is at page 5. The brief history of the temple, your lordship. According to Kalika Puran, when Shiva was going to Kailash with Sati, her father.
Deciding on individual temples, you know.
Yes, your lordship. What I'm submitting is that here there is no denomination.
Your religious practices, you
Yes,
can
lordship.
propound your point with reference to 25 or 26.
Lordship, what I'm submitting is, let me just start, your lordship, build up my argument. Lordship, this is a temple which is without a denomination. It is a rock, which is a cleft rock, and the shape is of the vagina, main vagina. Now, opposed to Lord Ayappan temple, this is a temple where menstruation is celebrated. There's a fair, there's Ambubachi Mela, and people as almost 25 lakh people. This is what I gathered the information, visit the Ambubachi Mela. Now, what happens during those 3 days, which are usually 22nd to 25th of June? The temple is closed. There are only women priests who are inside the temple. So what happens at large scale is Tantrism. So I'm on one of the practices which is widely practiced there, and it has all its vices. Tantrism, if done for a good purpose, has its effect, but Tantrism, if done for a purpose, which is only to indoctrinate one's mind, then it is certainly a practice which is to be stopped, at least at the public place. So if I may just read what is Tantrism, just the basic and the outline, it has got a Panch Karm, and Panch Karm involves what is known as 5M. Now these 5M are they're Madhya, that is alcohol, Mans, that is meat, Matsya, that is fish, Mudra, that is gesture, and Method, that is sexual intercourse. Now, tantric is not only male, they're also female. This is the latest. What happens is that when there is Tantra Vidya, like I will not relate it with any ism, but Tantrism is occultism, which has got a lot of practices which are opposed to human life. It violates Article 21 because in Makamakhya temple, there has been a practice of human sacrifices. When human sacrifice and when the temple door opens, it opens with the sacrifice of an animal. So this is a practice which is conducted, and lordships have, in a judgment of this honorable court, there has been a judicial deliberation on who will manage the affairs of the temple. So one is Tantrism. Second is that, again, the free access. So for 3 days when it is closed, it is fine that, 3 days may it be for whatever purpose. But what happens is that who are discriminated are the male. If there is a women priest inside and there are also sadhus who are allowed inside, then why not a women pilgrim? So this is one of my points which I am saying.
This side or this side, madam. First of all, we should.
No, Lordship, what I'm saying is that like Lord Ayappa temple, there's one particular practice which was not there, that was opposed to the temple of entry of women. Here, there are 3 things. One is the animal sacrifice. I said this is in direct violation of Cruelty to Animal Act. This honorable court has also heard matters relating to wildlife. And there's one particular temple in Kerala where elephants open their temple with, they worship. It is elephant who worship first. So there was a particular time when elephant cannot be transported. And if elephants
is run by whom? Kamakhya temple is run by whom?
It is a trust. It is a trust. Borderiers.
You are not representing the trust.
Lordship, the trust.
I understood your argument.
No, Lordship, may I just point out, Lord.
It is not a trust. It is run by tradition. There was a conflict that took place
In 2015.
Stored the traditional managers of the temple.
Lordship,
There is a litigation.
Lordship, Dolis took over. Yes, Dr. Dhawan is correct. He argued. This is 2019. 2015 volume 9.
We are not going into this dispute, madam. That's a separate.
Lordship, I'm on some practices which are continuing.
We are not on practices, please. We are on 25, 26. If you want to add anything,
yes,
you can speak. Otherwise, over.
Yes, your Lordship. Lordship, Article 25, 25 2B is the controlling or is the guiding article to Article 26. Article 26 is about the management. Article 25 2B is about the individual right. I, as an individual devotee, or I, as a pilgrim, when I go to Ma Kamakhya temple, those 3 days, people who are permitted are those, which is, there's a big mela. So the population which actually goes to that place is much more than what is the size of that hill. So what practices are done there, and the animal sacrifice, because I've personally gone there and I've seen every 10 minutes there's some animal which just cries. But what is shown on the YouTube, if we go by the media.
You understood it in this side in all fairness.
Yes,
Lordship.
We are at serial number 9.
Last limb of argument, Lordship, just one
So
second.
again, in the name of 26, you are again coming to some practices there.
We are at serial number 9.
May I just
Understand very well.
Lordship, may I just
You
argue
can clear-
may I just argue my last point? And this animal sacrifice, which
Now
Lord.
stop this animal sacrifice.
Please, we are not into it.
We are not into it. Thank you.
We are at serial number
We are
9.
giving
After lunch.
Lordship,
5 minutes time.
Lord-
Your argument is over, madam.
obliged, Lordship.
Thank you.
Case, Justice Iyengar reads essential practices as what is impervious to even social reform. Therefore, in his understanding, essential practices was an additional level of protection, that your religious practices are protected, but your essential religious practices are not even subject to social reform under subclause 2. So what was originally being seen, of course, in origin, it was essentially religious and essentially secular. But when it started becoming essential religious practice, one of the first statements of that, one is, of course, Dargah Committee, which we are all questioning. They will still be around or around public order. My lords, for instance, the first instance was...
Yes, sir.
Lordships, I have handed over an argument note today, my lords. I've recrafted the original submissions because much has been said.
Yes, you can start.
Yes, I'll straight away take lordships to this note, my lords. And then lordships would kindly see my volume 1.17, the excerpts, which is part of the compilation the nodal councils have given. I've footnoted most of the things, my lords. Lordships would kindly see. My argument, my lords, is broadly premised on the need for freedoms guaranteed under Part 3. The constitutional framers had acknowledged the historic challenges that this nation has faced, and the Constitution Assembly debates and also the judgments of this Honorable Court have extensively referred to the historical challenges of slavery, etc., etc. I've referred to them in my Part 1. Fundamental rights in Part 3 of the Constitution, Para 1, my lords. The heading I've given. Fundamental rights in Part 3 of the Constitution need to be understood having regard to the history of the nation. Here I've accepted, my lords, from Lordship's publication, The Courts of India, Past to Present. I'll just read. The 5,000 years of India's history, from the very dawn of that history, which might be considered almost the dawn of human history till today. So therefore, Lordships, when we are looking at the fundamental rights chapter 25 to 28 of religion, conscience, etc., Lordships would bear in mind the history of this land as judicially acknowledged. Now, Lordships, the second of the constitutional document and text itself. Where is the... would kindly mark just page 28 of this compilation, since I'm on this point of obsequies which are to be followed. These are all rituals. The third part is the political. Para 33, the heading I'll read, my lords. Or derivative periods that Dr. Dhawan has said.
Aspect, and there are many forms of nature worship, written submissions. I'm not going to try.
Advice of Sri Rama and Valmiki Ramayana to Bharata and adopt it as my submission, my lords. I'll place it. I hope this is a conversation in the Kachita Parva of Ayodhya Kanda of Valmiki Ramayana. The English version from the Gita Press I've extracted, my lords. I hope you do not patronize atheistic. Oh dear brother, for ignorant and conceited as they are skilled only in perverting the mind and thereby diverting people from the righteous path. Banking solely on their logical acumen, these men of perverted intellect preach nonsense even in the presence of foremost of books of Dharma. For a religious person, the dharmic values that my rituals or my religious texts prescribe me are paramount. Someone who is an atheist or a non-believer will have to be discarded even by this Honorable Court when you are testing my faith, my rights is my respectful submission. I'm so very grateful, my lords.
Thank you, Mr. Sridhar. Madam Madhu,
15 minutes at the very most, and if I make a repetitive point, please stop me. I won't. My lords, I appear in IA number 101671 of 2026. I'm handing over a set of written submissions. I'm not going to trouble you at this stage. Only one aspect I will refer to them. Now, my lords, we support the rights of worshippers of what are known as sacred groves. I'm going to only spend 2 minutes indicating to your lordships what this means, only for the purpose of being able to, my lords, your lordships to be able to appreciate the phenomenal diversity and magnitude of what your lordships are actually dealing with in practical terms. Now, my lords, this belief system, and we are concerned with sacred groves from Western Rajasthan, essentially. These are known as Devbans or Orans. Orans, which stretch over, my lords, vast stretches of, my lords, largely forest land. And where, my lords, the belief system is that, and this is as old as the ages, it's from the Rig Vedic, and we have traced all that in IA, etc. I'm not troubling you, but just to indicate that the manifestation of the divine goddess is in the forest itself. So there is a temple, a Kul Devi, etc. But the manifestation of divinity is essentially in the forest. So very close connection with the ecological aspect. And